Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, happy Halloween. How's everybody doing today? Holy Friday. Holy Friday. It's good. We're all good. However, I have a disclaimer. We're having somebody at the house right now working on it, and we might need to shut off power to this room. And I have a backup power supply and a battery backup. I just don't know how long that's going to last me. So if that needs to happen, I will let you guys know. We will probably go using the battery backup for a couple of minutes, and then we might start it afterwards, because we're working on some power stuff, and in order for everybody to stay safe, we turn off power. I hope everybody is doing well today. I have my ears. I'm supposed to be a wolf, more like a bitch, but it is what it is. Oh, all right. I gotta hide the tag. It's a dog-eat-dog world. Good. I'm wearing a milk. More information than I needed to know, Steven. More information. Yeah, these are my wolf ears. I got them for free, so maybe running an extension cord. No, we're having new outlet installed in the little room to hang the TV on the wall so that she doesn't knock it over. Plus, it just looks better. But we had the living room TV done last week, and he's hanging our sound bar right now. So we like a fucking overweight one. Yeah, 2025 Lizzo version. No. Anyway, there, got some shoulder. That's as good as it's gonna get today. I have no makeup on. My hair is still wet up in a ponytail. This is what you're getting. I'm trying to scare the kids when they come by tonight, and this is gonna do it. Anyway, we have a couple of documents to get to today. If y'all could just do me a favor and hit that like button for me and share this stream, because we're trying to get to 5K by next year. Working on it. Also, I'm not to grift, but I'm trying to upgrade the desk and the setup and stuff, because now this desk is too tiny. So all that costs money that I don't have. So if y'all do have any of that Starbucks money, that a top shelf tequila kind of money, if y'all could pass it my way, I would love that. If not, please just like and share. It helps me with the algorithm. Because of the fact of some of the topics I've been covering, like yesterday, I read the entire Maya brief with a little emergency house repair in between. Don't tell Mr. Squid, but I had to paint the wall yesterday to cover up baby Squid's little endeavors. However, that being said, we're going to get into this. We have 3 documents to go to, none of which are very long, except for the judges. But, and I know some of y'all have heard this already, but some of the people I've seen have big problems with the judge, and we're going to talk about it because we're just going to talk about it. So, let's see. There we go. I just have to edit this real quick. There we go. There. Now it's all nice and pretty for everybody. I'm still butthurt over the air fryer. See what I can do about a desk. I put one in the the Amazon. Actually, I'm putting it in the Amazon thing now. However, if it's not, it's one of those what I'm going to get regardless. But I put it in the gift list so y'all can see exactly what I'm getting because I'm transparent like that. Because I'm transparent like that. Although I have to change the color. So let me just change the color right now. There we go. There you go. So that is what I'm getting. I'm not putting it in there for the sake to say, here, buy this, because no. I'm putting it in there so you can see what I am getting, because I like to be transparent with you guys. That is why it is in there. So nobody go, oh my God, she's putting expensive shit in her thing. It's not the point. Not love the ears, following the laws, what judges are supposed to do. Too many judges today love to legislate from the bench. That's my favorite phrase these days. Legislate from the bench, which is not their job description. Yes, personal idea of fairness is trivial. And guess what? The law is not fair. It's just not. Just tell Mr. Squid she's artistic. Don't hold her back. Yeah, I painted yesterday. Don't tell. So, I did put it in there. There is some stuff in there. But I did get a teleprompter and a new tripod. So hopefully the camera looks decent today and it's a little more stable and it's not going to tip over as easily as the other one. This one's higher. It's more stable. I had to change some things around on my desk to fit it. Hence why I am needing the new desk, because this one is 42 inches and there's between 2 monitors, lights, a tripod, personal stuff, a keyboard. It's just too much. So we did you not see the pictures yesterday in the Discord? Check out the Discord. They're an experts Discord too. So check out it's more like graffiti. I'm not a fan of Belatho at all. I find he's lazy and doesn't do his job properly. Well, here's the thing. He's doing his job by the books. And unfortunately, shit doesn't move as fast as we want it to. Life isn't fair, neither is the law, which is one of the other reasons why we stress don't piss someone off enough to where when they threaten to sue you, they have the means and the opportunity. Because the law is not fair. It's not really fair to anyone, but it's especially not fair to time. And this is months and months and months of time that you will never get back. So, happy Halloween, love the ears. Remember what a female wolf dog is called. So you're all good. This was these were free when we went on vacation. So it's my free ears when you reserve a room there. You walk through the door and they hand you ears. So we have 3 pairs of these. So these ones are actually mine. I didn't steal them from the little. But I also didn't have to go shopping. All right, we're going to get into this. There are some things that I want to discuss that I saw people talk about, and I want to pick out by following the law. Cornell Law School, if you don't know, has a very good legal institute for the average layperson. So, oh, no. Yes, Roy, yes and no. That's where he's following the law, but we'll get to that. We'll get to this one first. Declaration of Randall Shochet in support of plaintiff's request for clerk's entry of default, document 124. Plaintiff Jeremy Hales and Elephant Shoe LLC, by and through undersigned counsel, pursuant to this order dated October 22nd, having now provided notice unequivocally stating that defendant Richard Luthmann in the second amended complaint is Richard Luthmann Jr., hereby files this declaration of Randall Shochet in support of plaintiff's request for clerk's entry of default against Richard Luthmann as follows. Yeah, Jeff, I agree with you, and we will get to that. I, Randall Shochet, declare and state as follows, but I honestly think that Randy kind of fucked up. Could have saved Jeremy a lot of money. Kind of fucked up. Didn't follow the law and kind of fucked up. So we're gonna get to it. So we're gonna get to it. Yeah, it's on the Discord. I'm over 18. I have personal knowledge of the facts set forth herein. I make this declaration in support of plaintiff's request for entry of clerk's entry of default. If called upon to do so, I could and would competently testify to the following facts set forth below. I'm an attorney duly licensed to practice before this court, and I'm counsel of record for plaintiff. On April 28th, plaintiff filed a first amended complaint, document 34, against Richard Luthmann. August 4th, Luthmann was served with a summons and copy of the complaint via substitute service of process. Time allowed for defendant Richard Luthmann to respond to the complaint has expired. Richard Luthmann has not been granted an extension of time to respond to the complaint, and defendant Richard Luthmann has not requested such an extension. Richard Luthmann has failed to answer or otherwise respond to the complaint, or otherwise serve a copy of an answer or other response upon plaintiff's attorney of record. I am informed and believed that defendant Richard Luthmann is not an infant or an incompetent person. Legal definition of incompetent is different, but the layperson's definition of incompetent, I think he fits the bill. But that's just my opinion, based on what I've seen. And upon information and belief, the service member's civil relief act doesn't apply. Could you imagine Luthmann in the fucking military? Oh, God forbid. Lord help us all, but that would be funny. I declare under penalty of perjury that under the laws of the U.S. that the foregoing is true and correct. 30th day of October. All right, that one's simple. Here's the controversial one. And I'm going to tell you why there's a difference between what we want to happen and what does happen. So, and I have to pull this up on my phone because I don't have it pulled up on in the internet here. However, all right, this is an order from the judge. Yay us. Presently before the court is plaintiff's motion to declare valid service of process and entry of default and other relief. For the reasons below, plaintiff's motion will be granted in part and denied in part. Under Rule 4E, individual defendants may be served by following state service laws or by delivering a copy of the summons and complaint to the individual personally. leaving a copy of each at individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there, or delivering a copy of each to an agent authorized to receive service of process. Similarly, Florida law permits service on an individual. Well, yeah, I think that was just that last one was just he has to write it. So here, let me just write it. Just a process issue, no problem. This is where people have a problem with the judge, but I don't. And I will explain why. Florida law permits service on an individual by delivering a copy of the original process to the person served with a copy of the complaint, or leaving the copies at his or her usual place of abode with any persons residing therein who is 15 years of age or older, and informing the person of their contents. Leaving service documents with a person other than the defendant can only be done at the individual's dwelling or usual place of abode. Under Florida law, the usual place of abode means the place where defendant is actually living at the time of service, not staying, actually living. Usual place of abode means a house in which dependent is then living or has her home, his or her home. For Luthmann, we'll go with a her. Plaintiffs state they have attempted to complete service at Florida addresses where defendant Luthmann is believed to reside based on his filings and other lawsuits. Plaintiff argues that process server affidavits show Luthmann has been evading service. Plaintiff claims that despite these evasion efforts, service was completed on August 4th when the service documents were left with defendant Luthmann's stepmother. Plaintiff asked the court to declare August 4th service to be valid. Plaintiff also requests that clerk's default be entered against Luthmann, and they seek fees and costs for service. Alternatively, plaintiffs seek additional time to serve defendant Luthmann and permission to serve him by email. Didn't we already learn you cannot serve? This is where I think, hold on, let's go to this one. This is my first point of contention with Randy, you're an idiot. You were already told service in Florida to an individual is illegal. So once again, you are wasting Jeremy's money by asking for something that you should fucking know. I fucking know it's illegal. I don't even live in Florida. Randy, get your fucking shit together. And if you are involved in too many lawsuits, maybe have Jeremy hire a different lawyer for some of them. Because this is not the judge's fault that you asked for something that is fucking illegal according to Florida law. So you are asking the judge to break Florida law. So when he denies that part of it, people are all up in arms. We've already established that's illegal in Florida. So strike one. Like you are asking for something that you know is illegal. Like, and it's like, and I think Randy might be a great person. However, you were already told and already put in writing that service by email in Florida is illegal. The judge literally put it in his last orders. So why are you asking for it again? Luthmann is not an LLC. He might have a YouTube channel, but just because you have a YouTube channel does not mean you are an LLC. It's like, but then the judge denies it and people get mad at the judge. It's like, no, the judge's job is to follow the fucking law. A lot of judges don't, and we get used to that. The judge is not there to make the law. If you want service by email to be legal in Florida, go to your fucking legislature. Call your fucking congressman, because that's how it's done. You can't just fucking tell the judge to do something. Yes, is it frustrating? Of course. But that's not the judge's problem. The judge is there to only interpret the laws, and the law is plain as fucking day. We read the damn statute the last time. I'll link that video, but we read the statute where it literally says service by email is illegal unless you are a corporation. That was another state they're asking to serve by email. That was not Florida last time. You're wrong. You're wrong because the judge put in his order that both Florida law and Wisconsin law are clear. So here. So they were asking, but the judge put in his order that Wisconsin was illegal and so was Florida. So regardless of whether they were talking or asking about Florida last time, the judge put in his order that Florida is illegal. So it's like you're asking for something that the judge already told you is illegal. And I'm looking at the last order from the judge. Let's see. 7:15, 10:21. Let's see if this one's it. I'm just looking at this. It's not that one. The judge literally said, that's the extension. So you're I hate to tell you you're wrong, but you're wrong. Like you're wrong. Because of the fact that the judge already had said that it was illegal in Florida. Let's see, email. Document 118. We're going to sidebar real quick. Florida law. Plaintiff have not cited any precedent from any court finding that Florida law authorizes service by email, nor could the court find any. What the court did find, however, were cases, including one from another judge on this court, stating Florida law does not authorize email service on individual defendants. Sorry, you're going to hear some noise. The only provision of Florida law cited in plaintiff's motion is Florida Statute 48.181. Plaintiffs have not, however, explained how this statute supports their position. So it's just, it literally says, like, you cannot, the judge literally said in a motion, which tells me when people are like, the judge doesn't read the motions. Well, Randy doesn't read the fucking judge's orders. So there's that. Like, I don't know what else to tell you. Like, so the judge literally included Florida law in one of his last orders. Therefore, Randy asking for service by email is not listening to what the judge already told him. Just a thought process there. Yeah. Plaintiff seeks additional time to serve defendant Luthmann and permission to serve him by email. Document 115 and 11. Document 118 was the order. So, defendant Luthmann was not lawfully served August 4th. The court does not believe that the service was properly completed on August 4th. Here's the other point of contention that I think the judge is right. I don't think it's fair, but I think it's what the law says. Plaintiffs acknowledge that defendant Luthmann has listed 2 addresses and filings submitted to the U.S. District Court for the Middle District of Florida. Plaintiffs argue that that one is defendant Luthmann's usual place of abode, even though they admit defendant Luthmann denies living there. Plaintiffs have provided insufficient evidence to substantiate their claim of defendant Luthmann's usual place of abode. Indeed, the information plaintiffs have provided seems to show that defendant Luthmann's usual place of abode is elsewhere, a residence he has listed on his address on court filings and other courts. Because the court lacks sufficient basis for concluding that that's his usual place of abode. The court does not find that service was completed by leaving the summons at that address with Luthmann's stepmother. See that Hollander case, finding that service was not completed where the evidence did not show the residence where the service documents were left at the defendant's usual place of abode. Thus, the court denies plaintiff's request to declare that defendant Luthmann was served on August 4th, 2025. The footnotes. Plaintiffs argue that defendant Luthmann is aware of the lawsuit and has discussed it on YouTube. That may be true. And although the court understands plaintiff's frustration, defendant Luthmann's knowledge of the lawsuit does not mean he has been lawfully served. Sad, frustrating, but accurate. A defendant's actual notice is not sufficient to cure defective executed service. However, I don't know why Randy didn't think of this sooner, but I have an idea. Moreover, the fact that the defendant may have actual notice of the pending suit does not excuse the plaintiff's defectively executed service. And then the footnote 2, for example, the affidavit does not state defendant Luthmann was seen entering and exiting the home, or that neighbors identified him as a resident of the home, or that defendant Luthmann's vehicle was regularly seen parked outside the home. Here is what I would have done. I have it pulled up on my phone. I will try to see if I can pull it up on my computer as easily as I have it here. Give me a Google search. 1 second. Florida statute 49.10. Doop, doop, doop. Doop, doop, doop. And I'm sorry this is tiny, but welcome to the internet. I think it's a big issue is the judge should have replied to the August filing before the end of October. He replied. His reply was August 8th or October 8th. The request to declare valid service on Luthmann was not till the end of September. Also, the judge has 60 days, I believe, to respond to anything. So it's now regarding the stepmother had told process server he was a resident of the home and had process server documented that conversation that could hypothetically influence the decision. Yeah. That's partially, but here's the thing. One, he never should have asked service by email. And secondly, the first frickin' time he said that he was evading and asked to properly or service or service issues. Affidavit of service by Paint Chips was September 25th. Motion declared valid service was the 29th. So there was no August document. Judge's order granting leave. Defendant Lee's motion to dismiss. Bone Break's motion to dismiss. Yeah, those were the only documents in August. So opposition order denying Kesey. Order granting Lee's motion for leave. Yeah, there was no August. There was no August motion for alternate service. So I don't know what you're referring to in that comment. I don't replied to the August filing before the end of October. There was no August filing that needed response. Bone Break's motion to dismiss. Defendant Lee's motion to dismiss. August was only 101 through 107, and none of them are Randy. Defendant's motion to quash, except for opposition to motion to or in relating to Kezi. None of these are in relation to Luthmann, by the way. The next 925 was the next document related to Luthmann. So that's 30 days. So even if it's 45, I still don't understand what you mean by that comment because that's not accurate. So it's it's 929 was motion to declare valid service. Then the two stricken motions were 10-7 and 10-7, 10-8. 10-8 was the order striking 116 and 117. Lucian Sr.'s motion for reconsideration was 10-14. So I'm not really sure. Order to show cause was 10-14. So no worries. That's why I like my receipts, because I check. That's why I have everything. Like, I have everything saved and I just bring it up because I'm like, let's not question things. Let's actually read receipts. So I have everything dated year, month, day, so I can see exactly. I'll go. I actually finally got myself organized. But here is what, if I were Randy, this is what I would have done from the very beginning of explaining that he's evading service. Once I explained once that he's evading service, I would have asked for this. Notice of action, publication, or proof. All notices of action except those referred to in paragraphs B and C shall be published during each week of 4 consecutive weeks, 4 publications being sufficient in some newspaper published in the county where the court is located. The newspaper shall meet the requirements as are prescribed below by law for such purpose. In proceedings 10 and 11, the clerk of court shall post notices of action in the manner prescribed by 49.11. One such notices of post are authorized by an indigent person. So, proof of publication shall be made by affidavit to the owner, publisher, proprietor, editor, business manager, or foreman, or any other office or employee of the newspaper having knowledge of such publication. The affidavit shall set forth, reading is hard, or have attached a copy of the notice, shall set forth the dates of each publication and otherwise comply with the requirements of law. Basically, 4 consecutive weeks, they have to be published in a newspaper where the court is located. Randy should have done that shit from the start. Would have been cheaper, would have been faster, and you don't have to personally serve. You can say, I published it in the newspaper. The fact that you didn't see it is a you problem, not a me problem. So that's what I would like. Like I said, like, I don't know why asking for something that the judge already told you was illegal. Dumb. I'm sorry. Like, I'm not a judge, but I hate being asked for shit that I already told people no to. I can't imagine the judge is any different. So that being said, Randy, publish it. Ask for alternate service by publication, just like you did with Teschendorf. Not hard. Yeah, in my opinion, Belythe was grateful for the delays because he foolishly thought he'd have a break from the case. Yeah. All right. Plaintiffs will be granted additional time to serve defendant Luthmann, but they are not permitted to serve him by email because the judge already told you it was fucking illegal. So why the fuck did you ask? Asking the judge to do something illegal asking me to do something illegal would piss me off. I hate when people ask me to do shit that I know is unethical and illegal. I can't imagine the judge feels much different. And maybe I can see this because I'm not personally invested, because I don't talk to anybody about, like, I talk to my pretty and Spawn, and that's literally it. I'm not personally invested. I don't talk to the defendants. I don't talk to except for John Cook comes in here. So bygones. With the exception of Jeremy associating me with the Hales ecosystem, which he can still sit and rotate on. I don't talk to anybody, so I can remain emotionless given I get emotional when I tell people shit. They don't believe me, and I show them receipts, and I'm like, "I told you so." I always come with receipts. That's why I do the documents, because the documents are my receipts. I don't knew this. I heard from this person. I heard from this person. If I hear someone say something, I will Google it, look it up, research it myself. Is I don't take what other people say as fact, because it's the telephone game. This person could have heard from that person. It's if it's not a primary source, I don't believe it. So it's yeah, it's illegal. It's not. It's an illegal process. No, you can't go to jail for it, but you can't go to jail for defamation either. But still not. Mm. The judge would have ordered that personal service be attempted again before he would approve a publication of service. Possibly. Possibly. However, you wouldn't have pissed off the judge asking him to do something that is not legal in Florida. I would rather be told, "Hey, you gotta try it again the old way before," and already put it in the judge's head that I'm thinking ahead, than asking the judge to do something that I'm not allowed to do. I Illegal sounds a little strong. Well, it's true. Anything that is not in the law and you are not following the law is illegal. The law says no process by or no service by email to an individual. Therefore, doing it would be illegal. Just a thought. I mean, but how much time and effort and money did he waste by asking for things that he knows aren't going to get approved? He's either overwhelmed or he's wasting Jeremy's money too. Just a thought. Which is frustrating to watch. If I were Jeremy, I'd be frustrated beyond belief. Like, you asked for something that you know is not allowed in the state of Florida. Why? Like, I'm not a lawyer. I'm not a paralegal, but I have fucking common sense. And I know not to ask for something that the judge already told me I couldn't do. Just the court must next consider plaintiff's request for additional time to serve defendant Luthmann and allow service by email. Plaintiff's request to serve defendant Luthmann by email would be denied for the reasons previously explained by this court in an order involving another defendant in this case. If I would have just read ahead, I wouldn't have had to search for the document the judge would have told me. This leaves plaintiff's request for additional time to serve defendant Luthmann. If a defendant is not served within 90 days after the complaint is filed, the court, on a motion or on its own after notice to the plaintiff, must dismiss the action without prejudice against that defendant or order that service be made within a specific time. Footnote, even if plaintiff had served defendant Luthmann on August 4th, that service would have been untimely. Defendant Luthmann was initially named as a defendant in the first amended complaint filed on April 28th. Thus, service of defendant Luthmann was due by July 28th. See Federal Rules of Civil Procedure 4M, providing a 90-day time limit for service, while the court extended the deadline to serve other defendants, documents 97 and 125. I really like that the judge puts receipts, because I should have trusted that he was going to do that and not gone and searched for it myself. Plaintiffs did not request an extension to serve defendant Luthmann until September 29th. Yeah, the judge could have dismissed that claim in the entire month of August. And this is the problem that I see as the problem. Other people may not feel this way, and that's fine. But I think Randy is overwhelmed. There's a lot of cases, a lot of paperwork, a lot of filings, and a lot of dates. That's the problem when you have a lot of defendants. One person can extend the case for months, and then the other person extends it for months. And you forget that you have a July 28th deadline and you don't remember until mid-September that you forgot to request an extension of time. The judge, if the judge was really against Randy, like everybody fucking claims, because the judge is literally only following Florida law, the judge could have dismissed it anytime between July 28th and September 29th, but he didn't, which means he gave Randy leeway, which means he's not against Randy. Like, in a court case, not every decision is going to go your way. It's just how it works. So, yeah. I have to say Randy has more wins than defeats, but you're bound to have a few defeats from time to time. Even Sarah Boone got some of her motions considered, and some of the decisions went Sarah Boone's way. And we all know, I'm still waiting on her appeal, by the way. She has a new lawyer. We're still waiting on the appeal, but it's like only to corporations, not to individuals. Luthmann is not a corporation. I have the document 115, 118. The judge literally put in his order, so it not necessarily true. This is the judge's order. Florida law. Sorry. Florida law. Plaintiffs have, I read this already, but I'm going to read it again. Plaintiffs have not cited any precedent from any court finding that Florida law authorizes service by email, nor could the court find any. What the court did find, however, were cases stating Florida law does not authorize email service on individual defendants. So I hate to say you're wrong, but you're wrong. Northern District of Florida, October 28th, 2019, stating that Florida law does not provide service of process by email. And I believe that that's wrong. In 2025, service of email is probably the most appropriate means of alternative service, because who reads the newspaper? However, that's something that Florida residents have to go to their legislature. Wisconsin residents have to go to their legislature and say, change the law. You can't expect the judge to change it, because that's not legal. So, although in certain situations, Florida law authorizes email service on corporations, LLC, and other business entities, there appears to be no provision of Florida law that authorizes email service on individual defendants. Sorry. Like, so when someone tells me multiple times, well, Florida allows it on, no, Florida law does not allow it. Certain cases on corporations, LLCs, but not individual defendants. If Jeremy would have sued Richard Luthmann LLC, then possibly, but it's not. It's just not. Like, I'm tired of beating a dead horse, guys, because we've literally talked about this shit over and over and over again about how Florida law does not allow service to an individual through email. So plaintiffs did not request an extension to serve defendant Luthmann until September 29th, well after the service deadline had expired and after the August 4th, 2025 attempted service. The rule further provides that if plaintiff shows good cause for the failure, the court may extend service for time for an appropriate period. It's the importance of having a very detailed calendar as to what dates are coming up. It's only Randy and Doreen. Randy being an attorney on record, he has a full plate and has dozens of clients. Yeah, I like I said, like I think Randy's a good person. I just think he fucked up, and you know, good people can fuck up too. But it's literally the reason that I have. It's literally the reason that I have a giant ass planner. Is because if I don't write shit down, I forget. I lose track of weeks, days, you know, all of that. Isn't BB an LLC? Yeah, but he's been served. So, like, yeah, the concept of service against corporations is because you're usually dealing with the legal department, non-named defendant. Yeah, but which I think in 2025 that, you should be able to serve people by email because I don't know, even my 90-year-old grandfather had an email address. However, however, this is not a court problem. This is a legislature problem. Separation of powers, you can't legislate from the bench, even though we see judges do it all the time. When we actually see a judge that's just going by the law, people get pissed. It's fucking bizarre. Like, you know? Uh, yeah, it's the nature of the game. You y To win the war, you won't win all the battles. So, it's just one of those, eh, like, 2025, even I think it should be service by email. Most people have more than one email. However, it's not a judge problem. It's a legislature problem. I think Jeremy should use, like, one of the things that I really wish Jeremy would do, and he might be thinking about this, I don't know, I don't talk to him, I don't know what's going through his head, but using this case to advocate for things like using his 730,000 subscribers. If he did an email or a letter writing campaign to the Florida legislature for changing the law, it might actually do some good. I mean, it sure as hell do a lot better than me and my measly 4,000. But, like, it use the power that you have to change the law because it sucks for him, but it might make it easier for the next person. It's email, how do you prove service unless read receipts? But even then, who reads it? I think you can do email where you can see the way you set up the email, where you can see that it's been opened. I can't remember exactly what settings offhand, but I know there's a way that you can, because it happened at work all the time. Like, our boss would email us stuff, and it would send her a notification that said we opened the email. So that's how she knew who read it and who didn't. Just so there's 2025. I think there's a setting in email. I'm just not sure what it is offhand. But the rule further provides that if the plaintiff shows good cause for the failure, the court would extend the time for service for an appropriate period. But even in the absence of good cause, a district court has the discretion to extend the time for service of process. Lapone Dempsey, this is one of the judge's favorite things to cite in this case. Ugh. And to lose a war, you can win all the battles and lose the people if they're not given the truth by the media and the government. Just, yep. That's probably why it hasn't been changed, but I don't know. I'm not a Florida congressman, not a congressman. But if you think that it should be legal, I arc read for a few authors. The emailing system they use lets us know if the email has been read. Well, and I just thought, Chucky, what about this? If it, as this, how do you know that someone's secretary did not open it? That would not be legal service as a secretary. It is not necessarily a family member over the age of 18. The only thing that I can think of is like a technicality with that is if you're an employee, you're 16 or over. And generally speaking, according to law, you generally have to be 16 or have a parent's signature in most states. So I'm wondering if because they'd be an employee, they're over the age of 15. There you go. And secondly, they have direct contact because they have access to that email inbox. They have direct contact with that's basically proof, unless you're a hacker, that you have direct contact with the owner of that email. You know? So, I mean, that would probably work, you know? Based on the information provided by the plaintiff showing multiple attempts to complete service at different locations, the court finds good cause under Rule 4M to extend the service deadline to Defendant Luthmann, granting the extension of service deadline where the plaintiff has made diligent efforts to locate and serve a defendant. Even in the absence of a good cause, the apparent efforts by Defendant Luthmann to evade service would likely justify the court exercising its discretion under Rule 4M to grant plaintiff's extension. And I believe that's why up here, when the judge said, hey, by the way, you were supposed to do this by July 28th and you didn't ask until the end of September, I believe the judge is like, yeah, I know he's evading service. Here's the kicker. The judge has to follow the law. The judge can see this plain as day and is still like, this is all I can tell you. This is all I can do by law. This is all I can do. Stop asking me for things that you know aren't allowed. But I know he's evading service, so please ask me for something that you're allowed to do. Because he literally says, court finds good case under Rule 4M to extend the service deadline as to Luthmann. Even in the absence of good cause, the apparent efforts by Defendant Luthmann to evade service, the judge literally says it right there, which means I can't wait until Luthmann gets in front of this judge, because that would be, I might drive down to fucking Pensacola for that. Even in the Hornicamp v. Van Winkle Company, noting that evading service may justify the grant of an extension of time for service of process in the absence of good cause. The court, therefore, will grant plaintiff's extension of 120 days to serve Luthmann. Here's the kicker. That extension will apply retroactively to the previous service deadline of July 28th. Thus, Defendant Luthmann must be served by November 25th. Kicker with that, 4 weeks. So, what did I just do with that? When I tell you this is literally my planner, it's literally my planner. Because when I go through things like this, I instantly write down the dates to so that we're all on the same page. So the 25th is a Tuesday. So you have you could publish it on the 3rd, the 10th, the 17th, and the 24th. There's your 4 weeks, according to that Florida statute 49.10. There's his 4 weeks. He's been served. You meet the deadline. Everybody's happy. Just, the court will not award costs under FRCP 42 at this time, which makes sense. Plaintiff asks that Defendant Luthmann be ordered to pay fees and costs associated with service and the filing of their motion because Defendant Luthmann's refusal to waive service. Quote, in lieu of service of process, the plaintiff may mail the defendant a waiver of service summons and allow the defendant 30 days to return a waiver. Defendants are not required to waive formal service, and if they do not, the plaintiff must effect personal service. Footnote, because plaintiff's present motion was filed before the court's advisement on requesting extensions prior to deadlines, the court will not recommend dismissal at this time, but the court will reiterate its earlier warning. Plaintiff's counsel is reminded that a lawyer should request an extension of a deadline before it expires. And this is where I feel like he's just overwhelmed, because Randy doesn't seem like the type to normally just forget to do stuff. He's pretty diligent with having filings ready to go. It makes me wonder if a missed calendar date and then they just lost track of time with everything else going on. But this is where having too many defendants, having too many lawsuits is very problematic. So, plaintiff's counsel is hereby placed on notice that if a service deadline expires again in this case without an extension request having been sought before the deadline expires, then the extension will be denied and the dismissal recommended for lack of timely service. Rule 4D2 provides that if a defendant within the U.S. fails without good cause to sign and return a waiver requested by a plaintiff, the court must impose on the defendant the expenses later incurred in making service and the reasonable expenses, including attorney's fees, of any motion required to collect those service expenses. Thus, a defendant located in the U.S. who fails to comply with the request for a waiver of formal service can avoid liability for those caused only by showing good cause for its failure to comply. Sufficient cause should be rare, and a claim being unjust does not qualify as good cause for failure to waive service. Given defendant Luthmann may be liable for costs for failing to waive service under FRCP 4D2, he must be provided an opportunity to respond and show cause for why such costs should not be imposed. See FRC Judge forgot P 4D2 Advisories Committee Note to 1993 Amendment. Defendant failing to comply with a request for a waiver shall be given an opportunity to show good cause for the failure. Because defendant Luthmann has not been served, the court will deny the plaintiff's request for service costs without prejudice to later seeking such costs after he's been served. You can't give him TLDR. You can't ask him to pay for something that's never happened. Once again, not fair quite yet. However, the law is not fair. And you can't just change the law because you feel like it. Yeah. So the plaintiff's motion to declare valid service of process and entry of default and order other relief is granted in part to the extent the deadline to complete service to defendant Luthmann is retroactively extended by 120 days from July 28th. The deadline to serve defendant Luthmann is now November 25th. Motion is denied in part to the extent the court will not deem defendant Luthmann to have been served on August 4th. Denied in part to the extent the plaintiff sought permission to serve defendant Luthmann by email. I just this still makes me like cringe because I'm like, one way to piss somebody off is to ask him for something that you know you're not allowed to do. It drives me nuts when people do that, when they're like, hey, can you do this for me? It's like, I can't ethically do that, right? Motion is denied in part to the extent that the court will not direct the clerk of court to enter a default under FRCP 55A against Luthmann. If defendant Luthmann fails to timely respond after being properly served, then the plaintiff may request a clerk's default at that time. Motion is denied in part without prejudice to the extent that the court will not award service costs under FRCP 4D2 at this time. The plaintiff may refile a motion after defendant Luthmann has been served. Signed, Zachary Belatho. So, there's that. See, my comeback to this is he never asked for alternate service. That's legal. So by them saying, well, we found him at this address, technically by Florida law, serving someone at another address is alternative service. Randy never asked for it. The judge can't allow you to do something that you never asked for. Randy has to ask for it. It seems pretty trivial, but Randy has to ask for it. Belatho is literally following the Florida law, and he cited it there. And he cited why he made the decisions he made. He was actually on Randy's side because he could have dismissed it July 29th, and he didn't. So when people say the judge is against Randy, it's like, it's not. Yeah, Randy asked for service by email. Service by email is illegal in Florida. Is not allowed. Not allowed. Not allowed. Service by email in Florida to an individual is not allowed. Therefore, when Randy asks for service by email, it's fucking annoying me just reading it. I can't imagine the judge being like, I already told you. Like, the I brought up Florida statute 49.1, which is service by publication, which is what he should have asked for. Because now he has less than 4 weeks. You better write that. You better ask for service by publication. You better get that in on Monday. And then you better have those emails ready to, or those publications and those clips ready to go, published as soon as possible. I'm assuming even if Randy asks for it and it gets approved, even showing that they've started the process before the 25th, I'm not sure, may be enough for the judge to be like, yeah, because you've started the process and it is a month-long process. Yeah, newspaper. So, yep. Every court is like a huge game of Mother May I. Like, he sanctioned him because that was the right thing to do, but he's also going to sanction Bubbles. However, before we get back to that, my stance on the Bubbles thing, you cannot ethically you cannot sanction somebody on a case that's on a stay, because federal one is on a stay because of Lynette's bankruptcy. Bubbles will not get sanctioned until that bankruptcy is resolved. So, like, for everybody who's like, they haven't sanctioned yet. This is literally every freaking thing. This is really getting old because every stream that I do now is literally the same issues. Well, Bubbles hasn't been sanctioned yet. No fucking shit, people. No motherfucking shit. Like, there's reasons for that, and it has nothing to do with the judge. It has to do with ethics. You can't file paperwork on a court case that is on a stay. There's no other way to describe it. It's like, you put the pause button, you put it in the filing cabinet, and you can't touch it. You can't even touch it to add more paperwork. You just, like, so, yeah. He's telling Randy step by step on how Bolitho wants paint chip served. Yeah, he's literally laying it out. And that's the thing about, if you actually read all of Bolitho's orders, he literally tells you how to do it. He's like, this is what I want. You just have to actually read it, understand it, and not be pissed that he said no. Honestly, that wouldn't shock me. That I can't say one way or the other, but I would not be surprised. So, yeah, but Stacey, you get it, but you know how many times people have said, well, Bubbles still hasn't been sanctioned yet. Someone put it on Facebook last night in the Facebook group, and I know this person and I like them. I have no issues with them, but they still said, well, Bubbles hasn't been sanctioned yet. It's like, no shit. You can't. It's like putting a case on stay is like you put it in the filing cabinet and you can't touch it. You can't add any more paperwork. You can't do anything. Like, no. There's no paperwork adds. There's nothing. Like, you can't, like, you know. Last I knew, in the UK, you hand a photo, address, workplace, timetable if you can. They can serve you in the street if needed. They can serve you when they tried to serve Kezi outside his car. Remember that whole car chase situation? Is because they were trying to get him to stop in his car so they could serve him, and he evaded service. So, yeah, and I was always, and you've been here for a while, but you're one of my OGs, but you know that, like, monetary sanctions are like a speeding ticket. Hey, we're going to impose, a $500 speeding ticket. You pay a fine and you're good to go. Just don't fuck up again. Well, what Bubbles did is not, like, here, guys, the on ethics, I have an Florida legal, did you the ABA code of conduct is ABA Code of Judicial Conduct is freaking 70 pages long. The American Bar Association ethics is long. The Florida rules of the Florida or the local rules of the Northern District of Florida are like 70 pages long. The judge has to go through all of those with a fine-tooth comb to see what he is legally able to do. And because he's a magistrate judge, he has to talk to the district judge. And guess what? This is not their only freaking cases. They have hundreds of cases. So between the two of them, they probably have over 100 cases. So it takes a lot of time to go, hey, what are we able to do? Because the last thing you want to do is sanction someone like Bubbles and have Bubbles report it and being like, this is improper. This is not by the rules of Florida. This goes above the book. This is not what you're supposed to do according to the bar. So it takes time to figure out when you have hundreds of cases and you are now having to read not only case law for each of your cases and go through all that, but you're having to read bar complaints and code of conduct and take time and effort to figure out what you're legally able to do. Because this judge is a very by the book, and so is Hinkle. It's a very by the book. So they're not going to do anything that they're not authorized to do. And the last thing you want to do is sanction Bubbles and have Bubbles go, well, this is not according to this code of conduct or this or that. What you did was above and beyond. And now Bubbles starts trouble with the judge. So it's easy for us to sit back and be armchair lawyers and judge when we don't have their jobs. I know it gets frustrating, but how do you think it feels for the judge? He has to actually deal with these people. We just get to read about it. The judge actually has to, because technically it's that lips loophole. It's that lips loophole. And Randy probably thought it's most likely going to get restarted. I've said this before, and it's like beating a fucking dead horse again. So I'm just going to kind of sum it up before I have to go grab a beer. But it's like, it's not exactly like an appeal, but when you appeal something, everything is kind of in a holding process. I believe Randy was just like, everything is just holding. Let me not file this because then we're going to have to restart this process all over again. And it was just easier for him because the judge would probably be like, well, there's a hearing. Remember, that filing would be extra money, extra time, extra effort, extra paperwork. And when something isn't a holding pattern, if it was right after, say there was no government shutdown and they had that hearing on October 6th and it didn't get reinstated, October 7th, Randy would have filed that freaking paperwork. However, once they set that hearing date, technically speaking, it's not really dismissed, even though it is, because the bankruptcy judge set that hearing. That's kind of like nothing can happen to you until after this date, and we have a for sure yes or no answer. That would be my assumption as to why Randy didn't file paperwork, because he knew it would have been a waste of money. Well, yeah. Randy filed updates on, what Big Al was talking about was when her bankruptcy was technically dismissed. However, they set a hearing date for a motion for reinstatement. I call it the lips loophole. Technically speaking, it's dismissed, but technically it's not because they have a hearing still. So it's like it's that loophole of technically it's dismissed, but on a technicality, you still have a hearing set for this case, so it's technically not dismissed. And that's where people got mad at me, and it was like, eh, that's where my viewership went from, like, 200 to 300 or 250 to 300 to, like, 200 because I basically told the fucking chat that I was like, "I'm tired of telling you guys this, like, I get what you're saying, but you're wrong." Like, uh, so, you know. Yeah, I was live yesterday at that same time, finishing up my story from yesterday. So, I was able to catch the first 5 or 10 minutes of it, and then I had to finish what I was doing because I was reading through the entire, um, Take Care of Maya, appeal document yesterday. We had to do it in 2 parts because um I had to abruptly end the stream because of I had to go into mama emergency mode. Um, but, um, I had to finish it last night because I really didn't want to extend that, I didn't really want to extend that, um, emotional baggage out for, a whole 'nother time. However, um however, I did read the entire if you wanna see, my professional head explode, um, I had to paint the wall. So I got as much as I could out, um, I got as much as I could out, and then I had to, there was some paint over the top of it. So, yeah, you'd never know it was there, but we're just some things we just don't tell, so there's just some things we don't tell Mr. Squid about. So, uh, and the person who asked, there's the link to the Amazon list. Um, so yeah, I didn't even wanna get into that case, so crazy. Yeah, well, I took personal interest in that case, the Take Care of Maya case, because of the fact that I was gaslit by medical professionals for years, um, basically telling me that I was faking my pain, um, and faking my symptoms, and then to find out that the only way to fix my problem was for to get brain surgery and get a metal patch placed on your brain. So, um, I felt for her. I felt like a not that I never talked to her. I never had a personal interaction with her or her lawyers. The closest I've gotten is to discussing back and forth comments with Dr. Goodhair about a completely separate issue. Um, but he and I still have to get back to Dr. Goodhair about a certain topic in his lawsuit. However, uh, no, no. So I don't have a personal connection to her. However, based on the fact that I can sympathize with the pain that she goes through, my pain is not as severe as hers. Um, Also, the the unaliving situation or the self deletion situation, I can yes, thank you for that. Um, so oh, screenshot this. I was completely biased yesterday. I was I was completely biased yesterday. I was not even like there was that's why I had to get through it in one day. Um, it was like it's 5 hours. It's like an hour and 45 minutes on the first one. Then I had to like cut the stream short almost immediately because I had to take care of stuff before Mr. Squid got home. But after that, we had to get through it yesterday because I was not about to extend out that emotional roller coaster another couple days. No, no, no. I will be keeping an eye on it if Maya and her lawyers decide to do anything, refile, go back to trial. However, I had to get through that all in one day because of the. But if you want to see me rant about how I hate the medical industrial complex, it's a good watch. Um, because having not only been a chronic pain patient, were not even my coworkers, nursing staff, doctors, like they all looked at me with a hint of like sort of just non-believing me when I said I had pain, or they just thought I wanted to get out of shit. And then it was like it was scary to find out that I needed surgery, but it was so damn satisfying to know that I was right. Or like, hey, there's something more than just my shoes don't fit when I can't feel my feet, kind of a situation. It was I felt justified for the first time in years. Um, like, oh, yeah, he hates YouTube. He hates it, absolutely hates it. So sorry. But yesterday was a good watch if uh you want to see me rage on the court system and um call J Hatch every freaking name under the sun. So, you know, yeah, sometimes you just want to feel vindicated with like, see, I told you so. And when the neurologist finally um it- it's just one of those, she's broke according to her filed bankruptcy. Where did she get the money? Oh, not that, not Maya Kowalski. Um, if Maya Kowalski refiles, I'll be, or goes back to trial. That not out of the kitchen drawer. So, um, yeah, chronic pain patients are. It's like you can't see it, so it must not be real. But it's not as. It's that step in between like mental health and like a broken leg. Like, people accept that you have depression, anxiety, bipolar, whatever. People are now getting to where it's they believe you when you say that, but they still don't believe like neuropathic patients. It's just eh, it's a hard thing to deal with. Um, but it's one of the reasons that I want to cover it, because shit like that needs to be seen. Um, it's the hard um it's the hard topics. Yeah, the swear jar runneth over yesterday. Oh my god. Yes, the I was taking donations to the swear jar yesterday. Um, it was bad. Yeah, and everybody here should know how I feel about immunity from the judicial side. You should hear how I feel about immunity in the medical field. Um, if you want to rage on that case, yesterday would be a good stream for you, because I was raging. I was reading that and like telling that judge that he's a fucking idiot like the entire time. And it was kind of one of those where I understand the law and I understand that it's there, but I don't think it should apply the way that it was applied. So I was told my back pain was and falling was because I was fat and sad. Oh, speaking of falling, I am working on the scripting and the timing for the fall series. It'll be 3, maybe 4 weeks of videos. So you know, yeah, your swear jar was a 55-gallon drum yesterday. Oh my god, it was like 2. Um, he has to request it. So I'm hoping to see an order on Monday. I didn't see anything in the docket when I looked today, but I'm hoping on Monday that we will see an order requesting um publication, alternative service. He should have asked when he asked for Teschendorf. He should have asked. And I know he thought that it was gonna be approved in service, but, like, you should have had that shit, like, ugh, you should have had that, he should have had that ready to go. So, alright, then the last thing we have is just the unopposed motion for an extension of time to respond to defendant's motion to dismiss. Um So this is in court for an extension of time to respond to David Michael Teschendorf's motion to dismiss second amended complaint. In support of this motion, on October 24th, David Michael Teschendorf filed a motion to dismiss second amended complaint. Plaintiff's response is currently due 11/10. Plaintiff's counsel is currently preparing for an upcoming trial in another matter, which has required significant time and attention, making it difficult to adequately respond to defendant's motion by the current deadline. Plaintiff seeks a 15-day extension to file a response to defendant's motion to dismiss. Pursuant to Local Rule 7.1, undersigned counsel has confirmed with David Michael Teschendorf by email, who responded that he does not oppose the requested extension. Interesting. Why would anybody that is evading service have a problem with waiting an extra 15 days? Yeah. That email stuff irks me because it's like he literally told you, and even I know that he told you. And it's like, if I can remember that he told you, for all the people that are like, the judge doesn't read Randy's shit. Well, apparently Randy doesn't read the judge's shit either. Just saying. For all those people out there that say that the judge doesn't read Randy's motions, Randy doesn't read the judge's orders either. Where I think Randy thought that basically paint chips were served with all the controversy. He should have been thinking that there could be more problems too. And regardless of that, Randy was told 118 was October 8th. October 8th. Like, it was, Randy was told on October 8th. And it's just that you should have, I can't, I can't think of any excuse for it. Like, hi, baby. I just can't think of any, I don't know. This extension is not sought for purposes of delay. No, that would be like people evading service, but rather to allow plaintiffs sufficient time to prepare a comprehensive response to the issues raised to defendant's motion. Requested extension will not prejudice any party or unduly delay these proceedings. Yeah, because it can't move forward until all the defendants are served, and we still have one. So, wherefore plaintiffs respectfully request this court enter an order extending the time for plaintiffs to respond to defendant's motion by 15 days until 11/25. 11/25 is going to be a big day. 11/25 is, I can't believe it, but I know I plain ass missed the part about Florida email service, and it was right there. Sorry. Like, I usually don't do the I told you so, but lately it's been like, I told you we read this already. Like, the judge already said this. And it's like it's one of them things where it's like, y'all, why did Randy ask for something that the judge already said is illegal? It's like, it's just one of them situations where you just look at it and you go, what the actual? I don't know. Yeah, judge pretty much laid it out for Randy. He just needs to take it and run with it. Randy, forwarding, like, I know Randy or Doreen will never see this, but maybe someone will screenshot it or screen record it and send it to Jeremy. Not to tell y'all how to do your jobs, but statute 49.1, service by publication. 4 weeks in a row in a newspaper in the county of the court. Doesn't have to be the county where the person lives. To be the county of the court. Just a thought. I looked it up. I did my research. I did my due diligence. So I looked it up. I helped. Hey, Angel, I help? Did I help? Okay. Like, I helped. So hopefully, yeah, Randy should request an extension now. I did not look to see Florida, Northern District of Florida rules, but um, I think it would be safe to say, because it has to be 4 weeks in a row of publications, and if you start it before the deadline, that should be Randy would probably write a motion saying this is the deadline, um, or the deadline is next week. We are on 2 of 4 weeks of service. We only had 4 weeks. It took time to get it in, request publication, because he still has to write an order requesting alternate service by publication. He can't just do it. He has to ask. So, she nemesis, the good part about service by publication is the defendant doesn't actually have to see it. So, like, bye, Angie. So, once it's in the newspaper, it's in the newspaper. Like, if Teschendorf gets served by email, or by but not by email, by publication, because email in Wisconsin is illegal too. I'm gonna have my dad. I'm either gonna try to find it online, or I'm gonna have my dad buy me a paper that day and send it to me, and I will put that shit right here. That will be my that would be on my wall. Yeah. Well, the thing about service by email is once it's done, it's done. You're served. You can't evade service forever. That's the thing. These people think they can evade service forever, and it's like, that's not how this shit works. Alternative service by publication. You don't actually have to purchase that publication. It doesn't have to be in the county where you lived in, according to Florida statute. It has to be in the county of the court. So you technically may not even see that you've been served. However, you've been served. So Randy could have made that request in August, to be honest. That's what I'm saying. That's why I'm frustrated with Randy, because just from a devil's advocate perspective, he asked for email a second time, a first time for Luthmann, but a second time in this case, when he was already told that service by email was not possible. So when you're told something is not possible, you go back to the drawing board and you think of something else. You don't ask for the same shit again, hoping the judge will change his mind. This judge is a very by the rules, by the book, will take his time and due diligence. Should have him buy you 100 papers and make merch from the ad. That would be hilarious. Oh my God. Did Lynette? I have no idea. Not a clue. But on that note, y'all, I have to go. It is 4:00. We need to get ready to go trick-or-treating. So I did put a desk in the Amazon list. Like I said, it's not a, hey, I put a desk in the Amazon list, like, go buy it. It's a, here, this is what I'm probably 95% sure going to buy, unless I can find something better for cheaper. If there is a furniture contribution in there for things like that. So when I do things like the Amazon list, some people call me a grifter. However, I have not had any super chats during this whole stream. So you girls gotta figure out something. So that's how I gotta do it. So, because I don't make my living on super chats, because if you live by the super chat, you die by the super chat, and I don't have time for that. Anyway, y'all have a great day, and I will see you guys on the next one. Bye.